and Mr. Sean Tate. And then we will also expect Institute for Security Studies to arrive at around 14 hours, represented by Mr. David Bruce, and possibly Gun Free South Africa by Dr. Stanley Maphosa. So in the event one of the latter two arrives in the afternoon, we will have 3 or 4 of them appearing. And I must also indicate to you and the members of the public that these organizations are not appearing here as witnesses. They are appearing here to make their presentations, to give the committee more insight into the criminal justice system. They will share with us their observations, which will be very enriching to members of the committee. And my expectation is that they will also make recommendations on how they think the South African criminal justice system can be improved. What are the legislative and policy interventions that may be necessary for us to have a resilient and effective, efficient and responsive, and even accountable and ethical criminal justice system in the country. So they will not be required to go through the oath administration process. But before I hand over to the advocate to formally introduce them and make remarks, I see the hand of Honorable Nomvalo is up.
Yeah, no, thanks, Chair. It's up for 2 things, Chair. The first one is that we want to register our great feeling of unease by this amount of apologies. We can't weaken the work of this committee towards the end. So it must be reprimanded, Chair. And I think in future, apologies from each organization should not be more than 2. At least if there's 1 person, because we also have organizational commitments. At least if there's 1 person, that is why we're saying members, organizations which have more than 1 member are more privileged, because when 1 is absent, 1 should be available as a basic principle. That is the first one. Then the second one, Chair, is that we're hoping to have a meeting to deal with housekeeping issues yesterday, because we don't want to be ambushed on the position of this committee about the approach on the Paul O'Sullivan issue. We're hoping that we will be given an update yesterday by the legal team on how far they've gone in pursuit of our previous position on the matter. Because the last position we took is that Paul O'Sullivan must be subpoenaed. So I don't know if that is happening or it's not happening. The reason why we're raising this here and now is because in terms of the time that we have, we're only left with 2 weeks. So we don't want to be told on the 11th hour that we have not done the work of this committee, when by that time we would not be left with any option. So we want to be given an update, Chair, on what is transpiring on the matter, so that if needs be, we can also advise on the way forward. Thank you.
Okay. Honorable Breitenbach.
Thank you, Chair. Mine are housekeeping issues as well, so I'll save it for the housekeeping meeting. Thank you.
Okay. Honorable Sangwen.
Thank you very much, Chairperson. I want to agree with the notion that you would not want to weaken the work of the committee as we are on the last mile. But I think that we must not agree to things that are not provided for in the rules of Parliament. There is nothing in the rules that says a party can only have so many apologies, it can't have apologies. And I don't think that anybody exercising their right to submit an apology when they're not able to attend a meeting should be reprimanded. So we haven't had a tradition of coming to this meeting, accepting apologies, not accepting apologies, reprimanding others, not reprimanding others. I think parties must be allowed to make their own internal arrangements and ensure that members, as they fit, are able to submit apologies when they need to, Chair. And on the issue of, I know it's not my place to answer, Chair, but on the issue of Paul O'Sullivan, I thought the committee had taken a very clear decision that says that in the event that we get to the day where we need to finalize, and Mr. O'Sullivan, having been subpoenaed, has not yet appeared before the committee, then the committee would then still be able to supplement their report when he eventually comes before the committee. I just don't want us to create impressions that there are people who are more vested in and having Paulo O'Sullivan than others. I think it's a resolution of the committee, and I trust that when we have a housekeeping meeting, we'll be updated. Thank you, Chair.
Yeah. Honorable Kalabanat.
Thank you, Chair. Could you just clarify the witness for Thursday and Friday, Brown Mkhwanazi? Is he not coming at all? Is he coming? Has he been rescheduled? Or what is the situation there with him? Thank you.
Okay. Honorable Nombalo.
No, Chair, we can't roll a red carpet for unjustifiable excuses. We maintain the position. It's wrong, especially towards the end of the work of this committee, to have apologies from all members of the party. We don't want to be part of that kind of tradition. Even if you continue with it, you must continue knowing it, that as the MK party, we don't endorse that kind of practice. At least if there's one member that is not present, then other members must be present. Whether that's a political right, people were making all sorts of commitments here when we were beginning our work. Others were even saying they are prepared to work on weekends. Now the work is here. People are giving excuses. What is happening here today, Chair, is undesirable. And we're condemning it as the MK party to say you can't have a committee with many members who are not present in the committee. So if you endorse it on your own. We're not part of it. That is why we're always here as members of the MK party. As on the issue of Paul O'Sullivan, yes, we are more vested on it. Want Paul O'Sullivan to come and present himself here in the committee. And if it doesn't come, he must be subpoenaed. He must be subpoenaed. That is our position as the MK party. Thank you.
Honorable Skosana.
Thank you, Chair. I just wanted to add, that the issue of Paul O'Sullivan, this white supremacy, this attitude of undermining this core committee, and for us not even to be like kind of a kid gloves, should not be allowed here. If he has to be summoned before we finish this ad hoc committee, as we don't have any more days, we must be, I wanted to use another word, Chair, but let me reprimand myself. But indeed, this white supremacy should not be tolerated here. All the witnesses were here. He must appear here. If he doesn't want to, let's do everything in the book to have him here. Thank you, Chair.
Okay. No, it's fine, honorable members. I saw your hands were up and I decided to give you a chance to speak. All the things that you have said here are our decisions. And those decisions have not been changed anyway. I think the legal team is working on those matters and will accordingly give a report to the committee. With regard to attendance of meetings, it is not for me as the chairperson of this ad hoc committee to respond to your absence in this meeting. It's not my responsibility. Nobody must ask me a question why members are not here. I have not elected you to be here. And I have not sent any one of you to be a member of this committee. You have been elected as public representatives by South African voters and sent here by your parties. It's not me. I don't have a member in this parliament. I don't have a fiefdom here. So as to how you conduct yourself, how you attend meetings, and how you are answerable to South Africans who voted for you, it's your choice. And I would agree with members who say that we started very well and we must have the same endurance towards the finishing line. I'm just saying that from today onwards, I can't be answerable to apologies and absenteeism in the committee. And Honorable Nomvalo, in as much as I hear your sentiments, I'm not going to reprimand anybody why they are here or they are not here. I can't do that. I have not sent anybody to Parliament. So when we came here, sworn in as members of Parliament, my belief is that we made a choice. And the choice that we made is to serve. And there is nobody who is going to be reminded about the choice that they have made. Honorable Barnard, I think the legal team, together with the relevant section in Parliament, were still working on the matters of Mr. Brown Mkhwanazi. The report that I got this morning is that the statement is about ready, but there are security issues that he is raising, which the security section of Parliament must attend to. And once those matters are sorted, they will give us a report as to whether they are able to reach an agreement or not. Yes, but what Honorable Nomvalo and Honorable Breitenbach are saying, they are right that this matters belong to a committee housekeeping meeting where we should be able to deal with all of them exhaustively. Thank you so much, honorable members. Can I hand over to Advocate Arendse to formally introduce our guests and make any remarks that he thinks are necessary for the proceedings. Thank you so much.
Thank you, Honorable Chair, honorable members, and a formal welcome to our guests, Advocate Paul Hoffman, Senior Counsel, Director of Accountability Now, and also lead counsel in this seminal cases of Glenister 1 and 2. Is there 3? Pen 3? Okay, 3. And Sean Tate, Director of the African Policing Civilian Oversight Forum. Both made very helpful submissions to the committee for its consideration, especially on policy matters and proposed amendments to the legislation that speaks to the terms of reference of this committee. As you pointed out, Honorable Chair, there are not witnesses before you. I know Advocate Hoffman has sent us an unsigned affidavit. I'm not sure whether you want to swear them in, nevertheless. but I present to you both Advocate Hoffman and Sean Tate. I think, Paul, you up first. Thank you. Yeah, I otherwise have no other comments to make. Perhaps at the end, maybe pose or ask a few questions with your leave. Thank you, Chair.
Okay, what is your advice? Because where I'm standing, the impression I have is that they are not witnesses. Can we proceed without administering oath?
I think if they don't have any objections, then perhaps we should swear them in. There may be factual questions or issues that either they raise or one of the honorable committee members raise, in which case we want to confirm it for the record. And perhaps if they don't mind or have any objection, I would propose that they get sworn in formally, Chair.
Advocate, let's proceed because they are representing organizations. They are not coming as individuals who would have made submissions to request appearance before the committee. Is that fine with yourselves to proceed without Advocate Hoffman and Mr. Sontate? Are you fine?
Yes, that's perfectly in order. Thank you, Chair. I can help. The affidavit that Accountability Now submitted to this committee in September last year has actually been properly attested, and in its original form, it is with the Secretariat of the committee. The version that has been made available is simply a copy of the electronic version that was made available at the same time in order to enable the Secretariat to circulate the affidavit among the members of this committee. And that document, which is the basis of our submission, has been summarized, supplemented by a note which I prepared yesterday, thinking that I would be limited to an hour, which is very difficult for any lawyer to stop after just an hour. But as I understand it, the Secretary has an electronic copy of the note which compresses the 36 paragraph, 8-page affidavit into a 3-page document. So, and I'll speak to the latter document if that suits the committee.
No, we can proceed. How much time do you need to make a presentation?
Well, when I came here, I thought that I would have an hour. 35 minutes of that hour have gone already. But what I propose to do is speak to the notes for about half an hour and then take any questions which the members of the committee may wish to direct.
I think the best will be to allow both of you to present, and then we can interact. Is it fine?
Thank you, Chair. That I think is probably the most sensible way to go forward.
Okay.
So members of the committee should have the submission, which is an 8-page document, and then notes on the submission, which is a 3-page document. And if they haven't got it yet, they will be able to get it from the Secretariat. Suppose the main question that we have to ask ourselves at this stage in the proceedings is, what is the mischief that this committee is addressing through its deliberations, through the evidence that it's receiving, and now through the submissions being made by civil society organizations and others? And our submission in this regard is that the nub of the problem is that the criminal justice administration in South Africa is dysfunctional because corruption with impunity is rampant in the land. And that is what this committee is going to have to address from the point of view of Parliament, which in our submission will involve the revision of the criminal justice administration's capacity to deal with corruption effectively. And we rely in making this submission on the decision made by the majority judgment in Glenister 2 in 2011, in which the joint majority judgment of the Deputy Chief Justice Moseneke and Justice Cameron was to the effect that our law requires, our law demands is the word that they used. Our law demands a body, not several bodies, but a body outside executive control to deal effectively with corruption. Now that decision ought to have been translated into law, into legislation that this Parliament was, well, not this Parliament, but the previous Parliament was ordered to consider and to put on the statute book within 18 months of the judgment being handed down in March 2011. The matter was indeed debated in that Parliament then, and amendments were effected to the legislation that gave rise to the Hawks. The Hawks are currently on their third incarnation from a legislative point of view, but they continue to struggle when it comes to dealing with corruption effectively. And the reason for that is not hard to find. The Hawks are not a body outside executive control. The reason why we are here is because a member of the executive, the Minister of Police, saw fit to issue a directive purporting to close down the political killings task team, which by its very nature is a body that deals with corruption. Political killings happen because hitmen are greedy and because those who engage the hitmen are hungry, or should I say, crazy for power. And that toxic combination is a form of corruption which has not been addressed at any time since the law requires a single body outside executive control to deal with corruption. I think I must pause here with the first part of that statement by the court, when they say a body outside executive control. They are not referring to a collection of bodies, but to a single body. Now, this is not what has been the case in the past, nor is it the case today. The multi-agency approach to corruption in South Africa has been the approach since the new South Africa dawned. And so we have hubs, and we have task teams, and we have cooperation between various entities, but we don't have a single body outside executive control that is tasked with the business of effectively seeing off the corrupt in our midst. And this has very deleterious effects in relation to the trajectory of South Africa. The economy suffers because of it. South Africa ranks number 80 in Transparency International's Corruption Perception Index of 180 countries with a score of 41. This is below the average, as well as well below the ratings of the faster growing economies of Rwanda and Botswana, who rank at 57. Corruption is undoubtedly preventing the rapid economic growth of which South Africa is clearly capable and which is desperately needed to lift half of the population out of poverty. So if we approach the work of this commission, this committee, on the basis that it is necessary to adjust the system that is in place, then we have the guidance of the Constitutional Court, guidance which has not found its way onto the statute book yet, and guidance which needs to be on the statute book sooner rather than later. You will recall that the reason for the Glenister litigation was that the Scorpions, or Directorate of Special Operations, as it was officially called, were disbanded in 2009 following a resolution of the ANC that was taken at its Polokwane conference in December of 2007. You've heard evidence from the acting Minister of Police before this committee, and he has conceded that it was a mistake to close down the Scorpions. And the reason why it was a mistake is because the Scorpions were a prosecution-led body which sought to counter corruption on a single agency basis, and which was far too successful for its own good in dealing with corruption in high places among the politically connected and among the politicians of the day back then. So the Scorpions were closed down, and they were substituted from an investigative point of view by the Hawks, or Directorate of Priority Crime Investigation, and they were also left in the situation where their prosecutors remained, if they were prepared to remain, in the National Prosecuting Authority. And a lot of people, even to this day, even in high places, believe that the National Prosecuting Authority is an independent body. Now, that is not the case. If one looks carefully at section 174 of the Constitution, sorry, 179(4) of the Constitution, you will see there that there is a reference to the National Prosecuting Authority operating without fear, favor, or prejudice. But if you read the rest of the section, it's very clear that the Minister of Justice has final responsibility over the National Prosecuting Authority, and that the minister must concur in any policy decisions that are taken by the National Prosecuting Authority, which in effect means that the Minister of Justice has veto rights over whatever the prosecution service may want to do at any time, and can steer the prosecuting authority in the direction that the minister wants the prosecuting authority to go. It gets worse than that. The National Prosecuting Authority has no control over its budget. Its accounting officer is the Director General in the Department of Justice, an employee of the minister. And the effect of not having control of the purse strings within the NPA is to hobble it from the point of view of trying to effect changes that may improve its efficacy and effectiveness in the fight against crime in general, and in particular in the fight against the rampant corruption with impunity, which we suggest at Accountability Now, is the reason for South Africa's backward trajectory in relation to getting on top of the criminality that is unpunished, well rewarded in South Africa since the closure, the mistake of closing the Scorpions down back in 2009. If we go further into the innards of the legislation that pertains to the National Prosecuting Authority, it becomes plain that the phrase "without fear, favor, or prejudice," which many of us for a long time thought meant independent, is actually a reference to impartiality. You can see this if you compare the phraseology that is used in relation to the judiciary in section 165 of the Constitution and in relation to the Chapter 9 institutions in section 181 of the, or sorry, 180 of the Constitution, which make it clear that impartiality and independence are different things, and that to assume that the ability to act without fear, favor, or prejudice implies independence is a mistake. So, having regard to the finding of the court that a body, a single body, outside executive control is required in order to deal with the issues around countering corruption effectively, we have a structural problem in South Africa which relates to separating the investigative work, which is the work of the police, from the prosecutorial work, which is the constitutional function of the National Prosecuting Authority. What the court has said, and it has looked deep into the meaning of the Constitution in order to get to the conclusion it reached. It relies on section 7(2) of the Constitution, which is the famous section which says the state must respect, protect, promote, and fulfill the human rights guaranteed to all in the Bill of Rights. Now, you cannot do that if your system is leaking vast amounts of resources and cash and assets in the direction of those involved in tenderpreneurism or state capture or any of the features of corruption which we have experienced in South Africa since the demise of the Scorpions. The government has actually recognized that this problem needs to be addressed, and it has sought to do so by introducing what Deputy Minister John Jeffrey referred to as a stopgap measure, by introducing IDAC, the Investigative Directorate Against Corruption. And guess what? IDAC is situated within the National Prosecuting Authority. It's an investigative directorate, which means that the investigation powers that were taken away from the NPA have now been given back to the NPA in May 2024. And as a matter of law, IDAC is indistinguishable from the Scorpions of old. It's structured in exactly the same way, brought about by ordinary legislation, which was passed by a simple majority in Parliament, in the previous Parliament, not this Parliament, and signed into law just before the May 2024 election. And if you have regard to the size and the shape of IDAC, I believe it has 158 personnel. It's led by Andrea Johnson, who is the subject of a complaint to the public protector because she encourages her staff to fake it till you make it. And I think that has been dealt with in various fora, including her interview as a prospective but failed wannabe National Director of Public Prosecutions. That little body is expected to do what the Hawks have been unable to do. We know that the Hawks are not up to dealing with corruption in high places. They are part of the police, and the police must, as things are structured now, must answer to the Ministry of Police in the final analysis of the work that is done there. So what is required in our submission is what has been proposed by the Honourable Breitenbach, who is a member of this committee and will explain her thinking better than I can, that what is required to address this mess that is not giving us the sort of return on our investment in the criminal justice administration that we deserve. Her proposal is to establish and to enable a new Chapter 9 institution, which she calls the Anti-Corruption Commission. It's based upon the drafts that Accountability Now prepared in 2021 for the introduction of what we called an Integrity Commission. I suppose an Integrity Commission has been given a bad name because the one that we know, a part of the ANC, has not been as effective as the body envisaged by Honourable Breitenbach is intended to be. So the idea of a Chapter 9 institution is not written in stone. The court, when it said a body outside executive control, implored Parliament to make the reasonable decision of a reasonable decision maker in the circumstances. What we got out of that was the revised Hawks. Everybody agrees, including the President, that the Hawks are not up to the task of dealing with corruption in South Africa as it manifests in state capture, tenderpreneurism, and the like. So the idea of a Chapter 9 institution seems to be the most obvious. None of the Chapter 9 institutions answer to the executive branch of government. Their reporting line would be to the relevant ministry, the relevant the relevant parliamentary portfolio committee, oversight body, and that will depend on which part of the activities of South Africa are covered by any particular Chapter 9 institution. And the idea of a Chapter 9 institution with a reporting line to the Justice Committee seems to be a familiar way of dealing with the requirement of a single body outside executive control, but I imagine it can be done in other ways. The other big advantage of making this body, this Anti-Corruption Commission, a Chapter 9 institution, is that to close it down, you would have to persuade 2/3 of Parliament, and we know today that the biggest party in Parliament has 35% of the seats in Parliament. So it would be very difficult to get to a point where 2/3 of Parliament would support the closure of any Chapter 9 institution, including that institution envisaged in the Breitenbach bills. But if we get ourselves to the point where the in Parliament, it would mean that 2/3 of the parties currently represented in Parliament would have to vote in favor, because in order to create a new Chapter 9 institution, in the same way as if you are closing down a Chapter 9 institution, a 2/3 majority is required. That is a difficulty, but it ought not to be a difficulty in relation to the Breitenbach bills, because the Breitenbach bills are a constitutionally pure way of addressing the dysfunction in the criminal justice administration, insofar as it is a problem in South Africa today. I see that I've got to noon, or just about noon, and I know that the diligent members of Parliament will read the affidavit that was presented in September and the references in it. And I imagine that the overworked members of Parliament will make do with the 3-page memo which summarizes it, which has been provided yesterday. So I'm going to invite honorable members to ask any questions that they may have in relation to the submission that we make, that the mischief that this committee is addressing is best dealt with by revising the system of criminal justice administration in a way that renders it effective in the fight against corruption.
Are you done, Advocate Hoffman?
I'm done if none of the members of the committee have any questions. If they do have any questions, I'm very happy to do my best to answer them.
No, we will come back to you. Is it my impression that your presentation is largely on legislative reform? Okay. Mr. Sontate.
Thank you very much, Honourable Chairperson. We were honoured to be able to make a submission to the committee in October. We focused our submission on the issues at hand and an aspect of the mandate of the committee, which was to consider the need for legislative, policy and institutional reforms to restore public confidence in the criminal justice system. And we focused on 2 issues that we thought pertinent. The first was strengthening Parliament's oversight functions, and the second on further insulating SAPS's operational command from executive interference. These relate to what we understood as the call to establish the committee and the ongoing work of the committee. So I'll turn to the first issue, and that is around strengthening Parliament's oversight functions. One of the kind of concerns raised by General Mkhwanazi in response to the press conference that precipitated these events was that he had previously submitted statements to Parliament and to the Portfolio Committee but that these, in his opinion, had not been taken further. And he was presented with, again, as he alleges, very little opportunity or option but to engage this through the press. Reflecting on this, we think that there certainly is pause for thought in terms of Parliament's ability to strengthen its responsiveness to allegations or issues, concerns that are brought to their attention. And these could include initiating an investigation for further information or potentially calling police management to further explain the situation. Honorable Chairperson, we believe that it is a critical duty of Parliament to respond and address allegations of political interference in policing. It is beyond an issue of discretion or political discretion for the committee. This is something that goes to the heart of the separation of powers. It goes to the heart of independent democratic policing, and these allegations demand serious and immediate attention and action by Parliament. So we submit that there are potentially areas where we can think through around further strengthening Parliament's ability to respond. One is the whole issue of recommendation and request that is made to the executive appearing before any of the portfolio committees, and the ability of those portfolio committees to follow up consistently, comprehensively, and in a decisive manner. How do we strengthen that environment so that there is a clarity and a responsiveness, and that is built into the action? I think a further area is the support for members of Parliament and the parliamentary staff, the committee secretaries, the content advisors, and the researchers with further capacity and training when it comes to a rapidly changing environment, particularly regarding criminal justice issues, the continuing evolution of policing, and South Africa's response to the crime and insecurity that is facing the country. The issues that come to our fore in vary and we anticipate will change over the course of time. That how we recognize corruption and interference today and how it manifests itself might not be the same way that it would manifest itself in 5 or 10 years. There could be a number of reasons around this: the advance of technology, the shifts in the way in which crime and insecurity manifest itself. There's a range of things, and it's important that Parliament has the capacity and is up to date to be able to recognize and respond with the best knowledge and evidence at its disposal. And then finally, The ability of Parliament in terms of being able to effectively track progress and the impacts of recommendations that it makes, that issues are brought to its attention, that it identifies an area of concern or a weakness, that it makes a recommendation that these be addressed, and that there is a timeous, coherent, and effective response from the department, and Parliament is able to track this and engage if further input is needed. And here too, we think that there's opportunity to strengthen the capacity and the work of Parliament looking into the future. So we offer a few suggestions, and we do so very humbly, in the sense that Parliament is appraised of its workings and its capacity to a far greater extent than what we are. But we thought perhaps the establishment of a subcommittee of the, in this instance, Portfolio Committee of Police, but it can be and potentially is relevant to all criminal justice system portfolio committees, with the mandate on an ongoing basis to scrutinize interaction between the executive, SAPS, and extended all law enforcement and criminal justice agencies. And that the monitoring and evaluation capacity of Parliament is strengthened with facilities that are able to track the implementation of its findings, recommendations, and the actions taken by the executive. With regards to the latter, and again, we submit humbly, is that this could potentially be established under the Office of the Speaker,